Good afternoon, everybody, and welcome to the first of our latest series of our lectures on the UK legal regime after Brexit. This first session is going to deal specifically with litigation in the UK courts, and we're trying to be very ambitious and to squeeze the 10 factors that every litigator needs to know about the new legal regime. So we've had 4 years of speculation about what the future relationship is going to be. And on Christmas Eve, we had the lovely present of the 2,000-page TCA wrapped and delivered, which is now being provisionally applied ahead of ratification. And the two obvious implications of this is that we now face a panoply of different layers of legislation, and certainly the lexicon is changing with the removal of any references to EU law and EU concepts as we know them. So what we're going to do in this session is we're going to divide it into 3 main tranches. We're going to talk about what the impact of the withdrawal agreement is for the future. Secondly, what the separation law envisages, and lastly, the impact of the TCA for our future relationship. And if their time allows, I'm going to try and do a question and answer session at the end of each tranche. So please, if you have any questions, flag them up in the Q&A and we will endeavour to deal with them if we can, or we'll deal with them in writing. And we've got a fairly rapid fire because we're trying to cover the ground fairly quickly. So I'm going to start without much further ado to talk about the Withdrawal Act. Jack, you're up first. Can you please explain to us what EU retained law really is about?
Yes, so retained EU law is a snapshot of EU law as it stood on one day, which is IP completion day, which was on the 31st of December, which is then converted into domestic law. There are 5 categories of what we call retained EU law, and I'll say something interesting about each briefly. So firstly, there's EU-derived domestic legislation. So the name retained EU law is somewhat of a misnomer. Despite the label, it also captures domestic law, which is in some way connected or related to the EU or the EEA. So the practical point here is that it's really important to always have the 2018 Act, the EU Withdrawal Act, by your side whenever you're considering a piece of domestic law, to consider whether it's retained EU law as well. And that's important because of all of the consequences that attach to a norm labelled as retained EU law. The second category is direct EU legislation. So that's EU regulations, EU decisions, and EU tertiary legislation, but not directives. The third category of retained EU law is saved directly effective rights. Now, one interesting topic here is what to do about directives. And there's an open question as to what the of a kind wording means in section 4.2 of the 2018 Act in relation to the retention of directive provisions. So there's an empirical approach and a conceptual approach. On the empirical approach, a directly effective right derived from a directive is retained only if the specific provision in question has been judicially determined in a case to be directly effective. Or the conceptual interpretation of the of a kind wording means that the words of a kind mean that rights contained in directives that satisfy the criteria for direct effect will be brought into domestic law, irrespective of whether there's been a domestic specific case. So the practical point here is really still to have a look at the directive when you're considering any retained domestic implementing legislation to see whether the directive's been properly implemented. Then you may well have a creative argument in litigation for saying that the directive provision itself is retained due to the of a kind wording. Fourthly, we have retained case law, and I know we're going to pick that up in later discussions. And finally, you have retained general principles of law. Now, there's an exclusion for that category because there's no right of action in domestic law now based on a failure to comply with any of the general principles of EU law. That exclusion is in Schedule 1 of the 2018 Act, but it's subject to an important exception in paragraph 39 of Schedule 8, 7 schedules later in the Act. And in short, there are still clever ways still use retained case law, which uses retained general principles. So there's lots for us litigators to be creatively arguing about.
Thanks, Jack. I'm going to move on now. Morag Ross QC is at Axiom Advocates in Scotland. She was very prominent in the Whiteman litigation about the revocability of Article 50. And Morag, we discuss how do you think courts are going to interpret, courts both in Scotland and in England and Wales, how do you think they're going to interpret EU retained law and what difficulties might arise?
Sure, thanks very much. I mean, briefly, they're going to interpret it with care, slowly and cautiously. I think any departure from EU law, from retained law, is likely to happen in that way. Parliament doesn't often go about telling the courts how to go about doing their job. But of course, in this case, in this Act, there are quite specific statutory directions as to which courts may do what. In the Act, the 2018 Act, there's particular provision that questions as to validity, meaning or effect of retained EU law are to be decided so far as that law has not been subsequently modified in accordance with any retained case law and any retained general principles of EU law. So the starting position is that it has to be a consistent interpretation, but not at the top level, so not necessarily at the top level. So the UK Supreme Court is not to be bound by retained EU case law, nor the High Court of Justiciary, which is Scotland's final court of criminal appeal, when it's sitting as such, which subject to some exceptions. So those courts may depart from retained EU case law. There are some exceptions. There are certain exceptions in relation to competition law, where courts and tribunals and the Competition and Markets Authority may depart from EU case law. But there are now also provisions in secondary legislation which designate certain courts as relevant courts. There are a number of those, but in particular, they include the Court of Appeal, the Inner House of the Court of Session, and the Court of Appeal in Northern Ireland, though there are others. Relevant courts are not bound by retained EU case law, except where there is post-transition case law, which modifies or applies that retained EU case law and which is binding on the relevant courts. So the normal considerations of what is binding on whom would apply. So for these courts, there is freedom to depart from retained case law, provided there's no post-transition binding authority, but they must apply the same test as the Supreme Court would apply in deciding whether to depart from the case law of the Supreme Court. That, it has to be said, is not actually that much of a test, because it's only where it appears right to do so. So a more free-ranging test, it would be harder to find. What's that likely to mean in the future? Well, the context and the legislation obviously are both new, but there is no great novelty really in the approach. Courts in the UK are well used to weighing up the value of authority from other jurisdictions. It's just part of the job. Of course, there are different jurisdictions already within the UK, and the courts, especially in Scotland and in a different way in Northern Ireland, given their size relative to England and Wales, are well accustomed to considering the neighbouring jurisdiction. Nor is judicial decision-making in a changed and developing constitutional context a new thing, not after 20 years of devolution. And the UK Supreme Court in particular is well used to that. If this is seen as an invitation to the courts to embrace the release from the bounds of EU law, it's not likely to be an invitation that is taken up with great alacrity. Courts, of course, will be aware of the potential wider consequences. The default will probably be to adhere to what has gone before. So litigants who are seeking to push test cases to effect major departures are likely to have to work very hard indeed, and will probably be disappointed, at least in the short term. As time passes, of course, and when the Supreme Court has taken the opportunity to set the tone, but it may change, but at the moment it's probably slow and steady.
Thank you. I'm now going to pass back to Jack. I didn't introduce Jack, but that's partly because he needs no introduction. He's one of the lead protagonists behind the EU Relations blog on the Monks website. He's been a very active junior in the Miller 1 litigation and a public commentator on all things Brexit. So Jack, we've looked about how the courts are going to interpret it. For private parties, suppose they want to actually challenge EU retained law, and obviously that also includes any modifications that might be implemented through the Henry VIII powers or by Parliament at a later date. How do you see that working out in a litigation sphere?
Yeah, so let's start with what those modifications are likely to be, because I think it's important to bear in mind that there are three separate levels to those regulations. So first of all, you have the retained EU law that's been immediately amended by regulations under the 2018 Act's Henry VIII powers in Section 8 to correct for deficiencies. So a practical point here already is that you can't just look up the retained EU law that we've copied and pasted across. You immediately have to find the domestic regulations which amend it. But there's also then a second level, because what you then have is other regulations amending the first set of regulations to take into account, for example, the withdrawal agreement. So you have to find the amendments to the amendments. Then the third level is you may well then have other regulations or pieces of domestic primary legislation enacted under the Future Relationship Act, for example, implementing the TCA, which again amend the retained EU law. So my practical tip already is you have to look, when you're deciding to challenge any regulations, at what is the amending provision in the first place. You have to do the forensic exercise of looking at where the amendments come from. Now that's particularly important because of the different hierarchies attributed to retained EU law on the one hand and relevant separation agreement law and future relationship agreement law on the other. And also because the sources of the amendments change. So for example, in the Future Relationship Act, you have primary legislation making amendments on the face of the Act to what is in form secondary legislation of the retained EU law, which is highly intriguing. Now, I suspect that the heart of your question, though, is at the first level. So there's Section 8 deficiency regulations and how to challenge them. The power to make those regulations is drafted in Section 8 of the 2018 Act, the EU Withdrawal Act, very widely indeed on its face, but it has considerable limitations. Because it's secondary legislation, of course, it can be challenged on all the normal grounds of judicial review. And we know that, for example, in the Supreme Court case of the Public Law Project case in 2016. And there are likely to be a number of VIRES issues raised by litigants. And I give two examples. The first is the amendment actually correcting a deficiency, so-called, that's listed in the Act? The list is long, but I think it's really important to remember that the white paper introducing the then bill stated, and I quote, "It is not a vehicle for policy changes." So I suspect there's going to be a lot of cases alleging that substantive and policy changes, not mere deficiencies correcting things like EU Commission and removing that reference. There's going to be all sorts of challenges, and they are susceptible to challenge on that ground. There's not really a deficiency error. And then secondly, any deficiency has to arise from Brexit. Now, just because Brexit gives the opportunity for some changes, that doesn't actually mean that the deficiency itself necessarily arises from Brexit on one view. And that would be really interesting to see how the courts interpret the phrase arising from in Section 8. So in short, there's a scope for a lot of challenges because so much of this is done by secondary legislation now.
Thank you. I'm now going to move to Tom. Tom's an expert in public international law. He's on the Attorney General's A panel for WTO work and public international law. Tom, in terms of UK clients, if they want to try and challenge or litigate government measures on the basis that somehow they're incompatible with EU retained law, what options do you foresee?
I think there's some change in the options available, but the first thing to highlight is it depends what sort of government action you're challenging. So if it's conduct by the executive, that conduct can be challenged in normal public law, through normal public law remedies on the basis that the executive is acting contrary to retained EU law. So you could get the normal sort of remedies you get from any UK court when the executive contravenes a statute, and you can get an award of nullity. So you've got that traditional remedy still in place. But where things start to change are when we turn to other actors. So when the legislature is acting, it used to be the case that primary legislation could be disapplied or set aside on the basis of the EU law doctrine of supremacy. Now that remedy is removed for legislation that is passed after the end of the transition period. It is, however, available in respect of legislation that's passed before the end of the transition period. So there's an important loss of that EU remedy. There's another EU law remedy which is also lost, which is the Frankovich damages remedy. In general, you can't receive Frankovich damages remedies for conduct after the end of the transition period. They are still available for conduct before the end of the transition period, but they're subject to limitations, in particular, a shorter limitation period. Now, none of this is going to cut across obtaining damages from the government on other grounds, so non-Frankovich grounds, so more traditional public law claims in tort or public law claims through restitution. So the bottom line is the remedies are still there. You have to squeeze it into traditional public law remedies. What you don't have are two supercharged EU remedies. So you don't have the supercharged remedy of disapplying a legislation, which is very unusual, both domestically and in public international law, and the remedy of getting Frankovich damages, which is also very unusual in trade treaties. Normal trade treaties give you no damages at all and just a prospective declaration. And both of those are lost for conduct going forward.
Tom, do you think there's any opportunity to try and sort of graft a domestic equivalent to Frankovich damages and try and create a remedy in damages out of whether it's existing retained EU case law, obviously not Frankovich itself, but all through other domestic equivalents to create some kind of innovative or creative route through to damages?
Yeah, I mean, I'd say that there is, but I wouldn't describe it as innovative. I would just graft on retained EU law on the normal remedies for breach of statutory duty, misfeasance in public office, or restitution. There's no reason to treat that body of law separately in order to create those remedies. And we shouldn't lose sight of the fact that if there are very specific statutory remedies that were derived from EU law that were available against the state, those will remain. It's just these grand general remedies, Frankovich damages and supremacy, that are gone.
Because I was wondering, if you're looking at kind of allegations of discrimination, you've got an obvious domestic parallel with the public sector equality duty, which also sounds in damages in the UK. So you might be able to sort of draw on that regime to find a route through to damages. And again, Article 1, Protocol 1, that sort of overlap with exceptional. And I don't think many cases are going to fall into that sort of camp, but whether there's a way of grafting on those sorts of damages routes. I don't know, Jack, if you're aware of other EU routes through to damages, it might be possible.
Yeah, I think, for example, you've still got the retained EU law in the procurement field, which gives rights to damages. I think what would be interesting is San Giorgio, for example, is a retained EU case law. So it'd be interesting to see whether the courts do run with that sort of case law and see whether there's a domestic regime for damages for breach of retained EU law. As Tom says, I think it's already there in the retained law, and it'll be interesting to see how UK courts get used to damages claims that historically is not readily available in pure public law terms domestically.
Yeah, and obviously state aid would be another regime as well, where there's a direct right to damages, or what's now called covered entities under services of general economic interest and statutory monopolies. So I think there are still recourses. I think what we'll do, we've got one technical question, which I think we may try and cover in writing rather than discuss now. We're going to move into the second tranche, which is the impact of the withdrawal agreement. And here it's the distinction between EU retained law and separation agreement law. We've all got to get up to speed with all this new terminology. Jack, can you give us a brief noddy tutorial, please? Yeah,
and what is relevant separation agreement law, which is quite a mouthful. So in short, the EU Withdrawal Agreement Act, the EU WA 2020, implements the withdrawal agreement, including the NI protocol, the EE separation agreement, and the Swiss citizenship rights agreement. And it then calls that domestic law that's implementing those three agreements relevant separation agreement law. Now, the 2020 Act does this by amending the 2018 Act. So you end up with lots of sections with letters afterwards as well. But a practical point to be aware of is that the 2020 Act also has its own freestanding provisions, in particular the citizenship rights provisions. So you have to have both acts to hand at the same time. You can't just look at one thinking that the 2018 Act does it all. The 2020 Act deploys a couple of techniques for implementing those three withdrawal agreements. So for some provisions of the international agreements, there are detailed provisions on the face of domestic law in the Act, and then a slew of domestic implementing regulations that I've already suggested and alluded to. But more generally, the Act also, for most of the withdrawal agreements provisions, has a very broad and very wide conduit pipe that, for example, in section 7A, it reads very much like section 2.1 of the ECA. So it says, for example, all such rights, powers, liabilities, obligations, and restrictions from time to time created or arising by or under the withdrawal agreement are without further enactment given legal effect in the UK. So it's just taking a step back and again thinking practically, what it means is you also need on your desk, alongside the two acts, a copy of the withdrawal agreement itself to actually know what your rights and obligations are. And I think Tom will probably touch upon preliminary references. That's not mentioned at all on the face of the Act, but that very wide conduit pipe in section 7A brings in the jurisdiction of the ECJ still. And my last point on this is just to think in terms of the hierarchy between retained EU law on the one hand and then relevant separation agreement law on the other. Now, as Tom's already mentioned, retained EU law is supreme over all pre-IP completion day law, so anything pre-existing the 31st of December 2020, but it's not supreme over later law. Now, this is different in relation to relevant separation agreement law. Now, that is supreme over all other domestic law, which includes retained EU law. So if there's a conflict between the two, you go with relevant separation agreement law. And it's also the case whether the relevant separation agreement law is pre-existing or post-dating the other act or norm that you're considering. So it's got supremacy forwards and backwards looking. So you really do have to have a close read of the Act to work out the interrelationship between the different sorts of law that we now have in the UK, and it's a real minefield.
Thank you. I've actually just invested in one of these, which has sort of tripled in size since the time I had before Brexit.
Yeah, we need to come up with the retained EU law one, which has, it would be really helpful to have the corresponding provisions of the withdrawal agreement, the TCA, and the domestic implementation legislation. But it would take someone, I think, a whole year, and no doubt it will be amended in that time.
So, I mean, obviously, there's been a lot of focus recently on Northern Ireland and the Northern Ireland Protocol. We mustn't forget that actually, obviously, the UK comprises multiple different legal regimes. And so when we're looking at the implementation of the withdrawal agreement, Morag, how do you see that taking effect in the various, obviously we've only got a short time, but an overview of how it might be implemented in Northern Ireland or in your jurisdiction in Scotland?
Yeah. We could take a long time. I'm not going to, and I'm not going to repeat what Jack has said already about about 7A and the way in which that works to bring in the withdrawal agreement itself into domestic law in the UK. Moving from that, though, there's this, in addition to the at the high level, bringing it in 7A, there are also powers, of course, for ministers to make domestic implementing regulations for Part 3 of the withdrawal agreement, or the other separation issues. And I'd like to say a little bit about that, to touch on Northern Ireland, but really to think about where some of the the tensions and the complementary nature of the different jurisdictions in the UK where that might be significant. The other separation issues then, which will be the subject, have been the subject already in anticipation and will continue to be the subject of secondary legislation. What sorts of issues? There's a very long list. It's not just a handful of residuary bits and pieces. They cover starting with goods placed on the market, ongoing police and judicial cooperation in criminal matters, judicial cooperation in civil and commercial matters, ongoing public procurement, similar procedures to those. That is not exhaustive. Those are just a few. These are really big, substantial areas of law that affect current and future litigation in particular. There are some limits on what ministers may do. They may not increase taxes. There's no retrospectivity. They can't create criminal offences and no interference with the Human Rights Act or the devolution statutes. But subject to that, the ministers actually have very broad powers. Moving on then to Northern Ireland very briefly, there are particular provisions allowing for regulations in connection with the Northern Ireland Protocol. And these powers actually go further than the ministers' the general powers. They're not subject to the same restrictions on scope, and they also extend to the ability to modify the Act itself. That's not it, of course. The devolved authorities also have the power to make regulations covering the separation issues insofar as they are within their own areas of competence. And these are tucked into Schedule 2 outside the main provisions that we've already looked at or can see in Section 7 with the letters and 8. So some observations then in relation to Scotland. There's been a great number already of amending regulations put in place over the last months, anticipating the end of the transition period. And many of these, of course, have covered or at least touched on areas of devolved competence. And some time ago, there were protocols put in place to allow for scrutiny, and consent motions have been made, consent has routinely been given. That's been operating for some time. Obviously, there are strong interests, not least commercial interests, in maintaining consistency either side of the border, especially in the period that we've just experienced of much wider uncertainty. Why create more problems than you need to have? Now that things have moved on, though, is there more scope for divergence when it comes to secondary legislation in areas of devolved competence? Well, yes, there is such scope. Inescapably, there is a political context, and there's also a different legislative context. Shortly before Christmas, the Scottish Parliament passed the UK withdrawal from the EU Continuity Scotland Bill, which has yet to be enacted. This, of course, is the second continuity legislation. There was an attempt earlier. But its main purpose, the main purpose of this new provision, is to give Scottish ministers the power to keep the law in areas of devolved competence similar to EU law. These have been called the keeping pace powers. Now, there may be a debate for another day as to whether those powers are actually expressly needed. Could the Scottish ministers, with the wide powers that exist under the Act, not just legislate anyway? Well, perhaps, but the signal is clear. There is an intention to keep track with EU law. Will that mean future divergence in regulation in specific areas between Scotland on the one hand and England and Wales? Maybe. There are already, historically, even before Brexit, there have been different ways in which EU directives have been implemented either side of the border, so it wouldn't be entirely novel. But as things move on, there will be other pressures which are political and commercial to keep things in sync either side of the border. But it can't be assumed that everything will be the same for all time coming, especially when there is the pressure in Scotland to keep pace, to keep things in sync. It's inevitable that there will be some difference. What does this mean for litigation? Well, clearly, if there are Scottish interests involved, you need to pay attention. But so far as litigation elsewhere in the UK is concerned, don't assume it's all the same. That would be unsafe.
I think I'm just going to take a break and take some questions, because the questions box is starting to fill up, and I would encourage all participants to add any questions. Some of these go back to kind of the questions on damages and remedies that we were discussing in the first section, but I suppose that's also relevant to separation law. We've had a question about a specific regulation to deal with finance resources, and what would happen if the government didn't actually comply with a regulation that was part of EU retained law, and would there be any ways to enforce those obligations? Obviously, we've been talking and focusing on damages, but what about getting declaratory relief or getting kind of orders of mandamus to force governments to comply? Jack or Tom, do you have any comments on that, and whether you think that sort of those sorts of, or Morag, those sorts of remedies are available?
Very briefly, I think yes. I think there would be a claim for judicial review. You've of course got to not just look at the regulation, the EU regulation, but its retained counterpart, and bring it forward, and then track through the provisions of the Act. I can see that Morag and Tom both have just unmuted. So,
well, just to say I agree with that. So nothing from me anyway.
Yeah, not much to add. A declaratory relief may well be available but it might not be of great interest to the commercial operator. It might be a little bit more difficult to make the next step, but I imagine there will be a willingness to test that and to try. Nothing else to add to that. Yeah,
and obviously there's specific provisions in sort of state aid for ordering recovery of aid and direct remedies there as well. And so Morag, what kind of, if we're going to look at test cases coming forward, I think a lot of commercial litigators will suddenly be looking at the public law sphere to see whether there's routes here to defend their clients' commercial interests. What industry sectors do you think might be a hotbed for these types of test cases?
Well, I think the obvious ones at the moment are those that we see in the news, industries where there are products with short-term lifespan, where there may be a case where, unless something is done quickly, particular businesses or potentially whole sectors face difficulty. So fresh produce and fishing and shellfish and those sorts of things. But moving beyond the really obvious ones, and it's at the moment it's difficult to see exactly what the nature of the alleged breach would be. Quite hard to be specific about that. I think we're likely to move to a situation where it's going to be at the industry level rather than at individual businesses, unless they are very large and willing to take the risk to step into the litigation sphere straight away. But representative bodies, naturally it takes them time to work out what the impact is. You can see that is those are the sorts of areas. That's not set. I'm not being specific about sector. It's difficult to predict, and sometimes they can come from unexpected quarters.
Yeah, because I was thinking, if you've got a company that's suddenly having to face additional tariffs because their rules of origin mean that most of their components come from outside the EU, or they've suddenly they can't comply with the customs declaration. It's very hard to see how they're going to mount a damages action on the back of that, because where's the error of law that has produced that harm? It's really a change in policy, and it's the consequences of leaving the single market and the customs union, which was part of the government's prerogative. So, I think you've got to be realistic, I think, about what kind of claims can be brought, and really zoning in on what the error of law is to try and highlight that.
But if it's
what sort of errors do you think it would be?
If you can't diversify and it is the entirety of your business, then and for those, as I say, with shorter term interests, it may force them to do that quickly.
Yeah, I only just a small footnote really. I think tax customs are obvious areas, as are procurement and state subsidy areas. And I say that because there's going to be lots of litigation about Section 29 of the Future Relationship Act, which I know we'll talk about later. But these issues across the Act really do affect every area of commercial litigation. So there'll be a whole slew of issues to do with jurisdiction as well, and disputes to do with service, which can come up absolutely anywhere, of course. But I think all of these constitutional issues can come up in the most odd case. You only have to think about all the historic constitutional cases such as Thoburn, which lead to big constitutional cases and whole PhDs being written about them, and they're very interesting commercial cases really at heart.
So I think it's quite interesting to stand back and look at the government's red lines. Remember going back to the Lancaster House speech of Theresa May, and she set out that list of red lines that Brexit means Brexit and what Brexit was going to achieve. The direct effect has gone, supremacy has gone. We've got UK courts are going to be deciding how to interpret and apply the law. And one of those red lines was obviously to remove the jurisdiction and the influence of the Court of Justice. Has that been achieved, Tom? Do you think, is there any ongoing role for the Court of Justice now going forwards?
There is the short answer, but nowhere close to the grand role it used to have. But it is interesting that it still plays a role, and it will play a role for years to come. For domestic litigators, the two areas to really highlight are the citizens' rights provisions in the withdrawal agreement, where the CJAU is empowered to decide references about citizens' rights in that agreement. Now, that's a jurisdiction that will drop over time. So there's an 8-year time limit for that. It's a bit longer than 8, actually. But the test for that is different from the test all of us are used to as EU lawyers. All of us are used to a test where you make a reference if the answer is not clear and it's necessary to decide the dispute. The test here is simply whether the court decides that a reference is necessary to enable it to give judgment. And that's something new and unique, and it's difficult for me immediately to work out why an English court would decide that it doesn't know how to answer a question of law and needs help from another court. But it may well be that issues of consistency across different jurisdictions may come up. So that's the first big heading, citizens' rights in the withdrawal agreement. The second big heading is the Northern Ireland Protocol. And in the Northern Ireland Protocol, this isn't time limited. This is as long as the protocol stays, that jurisdiction stays. And it's a very wide jurisdiction. It is the traditional test, which has a duty to make a reference if something is not clear. And not only is the CJAU the body that's going to decide the meaning of that protocol, which may make some sense because most of that is applying EU law, but it is also the body that will decide on infractions against the UK on whether they're complying with that law or not. And that is very unusual in a trade treaty. It's a bit like if we have a bilateral trade treaty with the Australians, and we tell the Australians that deciding non-compliance with the treaty, the UK courts will do it. So we very much have a very strong role for the CJAU in those two areas. Now, that doesn't end the story. There are other areas which are more state to state and are less important to litigators. But for example, in the areas of budgets and old infractions during the transition period, there are various jurisdiction. The jurisdiction is still retained by the CJAU and will be for some time. But yeah, so the CJAU is still alive and kicking.
Thank you. Right, I'm now going to move forwards, looking to the future relationship and the new TCA, because obviously this is a state-to-state agreement which sets up an interstate dispute settlement procedure. Tom, do you see any room for direct rights of actions for individuals under the TCA? Is there any room for commercial lawyers or litigators to have a role in that process?
So the TCA is very, very clear about direct effect. It's a very traditional trade treaty in that it says, generally speaking, the agreement does not confer individual rights, and there's no duty to confer individual rights. That's Common Provision 16, and there's only one exception to that within the treaty, and that is MOBI SSC 67, which is basically about the protocol on social security. So it is very much a traditional trade treaty, which is giving standing at the interstate level and is not really giving standing to private individuals to ensure that there's compliance. So it's radically different from the system we had all these years under the EU treaties. Now, having said that, we're going to come to Section 29, which sort of reverses that position, but that is something that's not happening between the treaty parties. The treaty parties haven't really envisaged what the UK has done under Section 29. The treaty parties are looking at this very much as a traditional state-to-state enforcement with some exceptions. So I think the bottom line is we've got a very traditional sort of trade treaty. Now, if you go deeper into the treaty, there are various provisions that say that the parties have to create rights and standing for individuals. So for state aid, for public procurement, for competition, for labor and environment, there are very specific situations in which the treaty asks the parties to create rights for private parties, but they're very narrow. And I think it's fair to say that in general, we're looking at a very standard trade treaty, which is all about two states deciding what's appropriate, and private parties have very little ability to influence that process.
So if we try to sort of maybe pivot and say, well, is there another way for private litigants? Is there a way, Jack, that they could use the TCA to litigate against national government measures?
Yes,
and use that as the basis.
Yes, I think it's really important to start with the Act, precisely because of dualism, ironically. So Section 29, for example, makes provision for the implementation in domestic law of all otherwise unimplemented TCA provisions. Now, it provides, very intriguingly, that existing domestic law has effect, and I quote, with modifications as are required for the purposes of implementing in domestic law the TCA. Now, this, it seems to me, requires public authorities, private parties, and indeed the courts to conduct three exercises in respect of the international agreement, the TCA, and also the security agreement. First of all, to interpret the relevant provisions of the international agreement, as Tom has said, to see whether it's required to be implemented at the domestic law level. Secondly, to implement those provisions. And third, to modify other domestic law. So can we make use of Section 29 to litigate about the TCA in domestic courts? My strong answer to that is yes. And I think we can take two examples. So first of all, let's assume that, for argument's sake, that the procurement Brexit regulations, which removed any mention of EU entities, have not been updated. And so there's nothing on the face of any domestic regulations that tells public authorities that they cannot discriminate against EU entities. When we look at the TCA, however, the procurement provisions at the international law level require a domestic review process and EU entities not to be discriminated against. Let's take a second example. There's a subsidy control regime in the TCA. It sets out rights and obligations regarding private parties. But there's absolutely nothing in domestic law, with the EU state aid regime having been abolished by secondary legislation. So let's imagine that a public authority just reads the domestic law in my two examples. It finds none. So it discriminates in favour of UK businesses in a procurement competition, for example, or it grants a UK enterprise a lot of money. Can an aggrieved party go to court under Section 29? Now, my response to that is an emphatic yes, because they would be saying, in quite orthodox terms, I think, that the public authority has committed an error of law and acted unlawfully. Contrary to Section 29, it did not modify and apply domestic law as it should have. It should have looked at the TCA's provisions. We are domestic lawyers, so we start with the Act and do what the Act tells us to do. The Act has chosen a very specific way to implement the agreement in a very broad manner. It seemingly addressed everyone in the jurisdiction and simply says, and I'll repeat, that existing domestic law has effect with modifications as are required for the purposes of implementing in domestic law the TCA. So if the procurement regs or the subsidy control mechanisms that are set out in the international agreement were implemented in a more detailed way, then litigants could rely upon those. So just because Parliament has chosen a wide conduit pipe for the incorporation by reference, I don't think it makes any difference in my view. But lastly, just to conclude, I want to be clear about what I don't mean. I am not saying that private parties can go to a UK court and say that the UK is in breach of all provisions of the TCA generally. The Section 29 conduit pipe is, of course, materially limited by the nature of the agreement's provisions that are capable of flowing down it in the first place. So what is necessary to be implemented? My two examples are provisions where the TCA clearly envisages domestic law implementation. And indeed, you've seen all sorts of state subsidy control guidance being issued by the UK government, which tells public authorities that they have to comply with the state subsidy regime. Well, why is that so? You don't just look at the international agreement because of dualism. You do so because Section 29 incorporates it in a very broad way. And just to finish, I should lastly say that Section 29 doesn't apply to any other terms of the TCA that are specifically implemented. So if you look at Sections 26 and 22, for example, in the Act in relation to the VAT protocol and social security provisions, that's got a similar wording to Section 29, which talks about, in spite of domestic law, you have to comply with those protocols. So I think they've been implemented. So that's a very long answer to say, yes, I think there are lots of opportunities for litigation about the TCA in domestic courts, despite what the international agreement may say, ironically, because of dualism.
Yeah, I was also wondering whether there's a way of coming at this indirectly using kind of interpretation as a way through. I know we don't have the duty of sincere cooperation anymore, or that duty of consistency, but there are similar provisions in the TCA. If you look at the good faith and the cooperation provision, that's modelled very, very closely on the wording, the familiar wording in Article 4.3 of the TEU. Whether that has the same content is $1 million question, but there might be a way to infer some kind of consistency obligation in the interpretation and going forwards.
Well, Section 30 of the Future Relationship Act, which is where the Section 29 is found, does direct the domestic courts to interpret the TCA in accordance with customary international law of normal obligations of good faith, for example, which come in via that. So Section 30 would make very little sense, I think, if you couldn't rely upon TCA provisions in domestic law, because otherwise, why is the domestic court being directed to interpret the TCA? And I think it's doing so because you have to work out, despite what the international law agreement says, which of the provisions can have an effect in a domestic law plane, or at least envisage domestic law implications. And procurement, the VAT protocol, the subsidy control regime, and the social security provisions are prime examples of where the international agreement has been incorporated by cross-reference, really. And then, as you say, we've got to work out what Section 29 means with modifications as are required. Is it strike down? Is it the strong interpretation, leasing type ability? And I think we're going to have all sorts of fun with that.
And last question, Morag, if there are no direct rights for individuals in the TCA, are there softer ways in which private companies and their legal representatives can participate in the dispute settlement procedures? Or what role is there, if any? You may not think there's any at all.
That's a much wider question and necessarily a great deal more speculative. I mean, I think the starting point has to be, as Tom's already explained, and for the reasons he's given, obviously private parties won't have very much ability to influence the process, and if there isn't a domestic route through, as Jack has suggested, what is left? Well, as I say, it does become speculative, but there may be disputes, and those are not going to just take place in the abstract. States are not going to litigate against or enter into a dispute and a resolution of that for fun or to make an academic point. They will be bound up in, for example, in the effect on trade, and you find out about the effect on trade by asking those whose trade has been prejudiced by decisions or by operations or by the way in which the agreement's been implemented. And so that has to be, for that to be informed, it has to be based on experience of people who are affected, however directly or indirectly. And it has to be based on evidence. So it's possible that there may be scope for those who are affected to contribute evidence. The way in which they do that and their route into that, I think, is again something that is necessarily speculative. It's perhaps leaving the strictly legal or the territory of legal remedies into influencing and contributing, participating, putting views forward, lobbying. Yes, non-conventional means perhaps relative to ordinary litigation, but I'm sure others have other views. These are, as I say, are to an extent guesswork.
Well, I was combing through all the various provisions, both under the standard dispute settlement, but also under the rebalancing mechanisms for state aid and competition law and environmental labour standards. And you can see all these references there. They explicitly say you can't start these processes on conjecture. You've got to have evidence. And, they've got to take input from relevant persons and have consultations with domestic agencies. And I thought, well, is that a way through for parties to actually get involved? And there are other areas, like in the pharma sector, where there's no formal process for interested parties to participate, but they have been allowed to put in submissions and representations. So there might be indirect means, but obviously that remains to be seen. I think we're probably coming to the end of our session. I just wanted to see whether there's some questions. We've been trying to answer some questions in the chat where possible. And I think we've had a couple of questions on breach of statutory duty. I think we might just wrap up with that one, saying, well, are the criteria that dissimilar from Frankovich? And do we see that perhaps that's the route forward for obtaining revenues against the government? Don't know if anyone has any particular points on that to say.
I'll go, and Tom can jump straight in and correct me if I'm wrong. I think the answer in short is yes. I think it is very similar. The idea that breach of statutory duty, Frankovich damages itself is actually a breach of statutory duty. This was confirmed in a case I was in last year, the Arriva case, where the court found in the trains procurement litigation that a breach of Frankovich damages is actually a statutory tort duty subject to the 6-year limitation period. And so I think the tests are similar, and that's certainly one way of doing so. And then as to whether it would be possible to bring a challenge for damages for breach of the TCA, domesticated obligations, arguing a breach of statutory duty, I think that's fascinating. I mean, I touched on only the idea of it being unlawful and ultra vires because in my 2 examples, the public authority hasn't actually complied with the law it's meant to because it didn't modify its reading of domestic law, which I think puts them in an invidious situation. So whether a court would be very sympathetic, I think, to a public authority, at least in the short term, in terms of damages, because I think they would say, is it sufficiently serious breach and was it intended to give rise to damages? I'm not sure whether those criteria, if they copy across from the Frankovich type of cases, may well be satisfied. And you can just imagine a court saying, well, this is all pretty unfair in the short term. As time goes on, I think courts will expect more from public authorities once this all becomes obvious. And so if in a year or 2 a public authority was saying, oh, I didn't read the TCA, I had no idea how to comply with it, and there already been a case saying they had to, then perhaps the court will be more harsh. But I think in the short term, they may well be a bit more sympathetic. But that is a guess.
Yeah, I mean, I agree with what Jack was saying, and it may well be that the criteria for Frankovich are actually more constraining than the criteria under English law. Having said that, at the end of the day, whether there is a tort of breach of statutory duty, which sounds in damages, is ultimately a question of statutory interpretation as a matter of English law. And there might be a big question whether the English legislature, when it was passing this set of laws to domesticate retained EU law, wanted to allow for a damages remedy. And I think that will be the obstacle to that argument. But it's, I mean, certainly the right question to ask, and a very fertile ground for getting a remedy.
Last point from Morag. Obviously, the European Convention of Human Rights is hardwired into the TCA. And at one point, the government was planning to leave that convention, but looks like the TCA will fall away if the convention is removed. What role do you think human rights have, as well as an overlay, as a potential source of remedies on top of these provisions? And do you see that as adding anything?
Yes, I mean, the fact that it is there, perhaps it will contribute something to the interpretation of it. The availability of A1P1 remedies that's been a consistent feature for years, albeit not one that people have had to turn to because of the availability of remedies in other ways. Will that take on a renewed importance? I'm not sure that it will as a sort of direct alternative, because there's ways of construing that and interpreting that that will continue to be particular to the convention rights context. So I wouldn't just see it as you can just flip over into that as your route. It's more complicated than that. Departure from the convention, well, it might pull the TCA down, but perhaps bringing it back to the UK context, the consequences of such a move would also be profoundly damaging to an already fragile and changing constitutional relationship within the UK. The idea that would be consented to, certainly in Scotland, leave alone Northern Ireland, is a really difficult question. That would open up massive consequences that, whilst they might not be, they'll be of a different character to those that we've been discussing in the commercial context. But A1P1, I think, would become a small issue relative to the consequences that would follow there.
Well, thank you. We have managed to get through the top 10 things that litigators need to know on a rapid whistle-stop tour. So congratulations to the panelists for dealing with that demanding agenda. We will be putting a video of this summary up on the EU Relations blog. I'm conscious we haven't managed to answer all of the questions, but we will try and follow those up and come back to you if you've given your name. If you have any questions that you didn't think of at the time, or you think subsequently, you can always email and we'll try and come back with some questions, or you may see another blog post. So I think that the conclusion of today's session is, obviously there are a lot of exciting issues that will remain to be determined. We will be trying to keep track on those, and we'll be pontificating on the blog. So please, if you're not already subscribed, sign up and watch this space. But thank you very much for attending. And we will be having more of these series every Thursday at 1 o'clock for the next few weeks. So please look at our website for the agenda of the topics that are coming up. But thank you very much. Bye, everybody.